Welcome to another episode of 20 Minutes with Troy, where I sit down with a wide variety of professionals to uncover and discuss the issues that dentists face in their personal and practice lives. These interviews are an extension of the work of my firm, Advisory Resource Group, which has been assisting the needs of dentists and medical professionals as an advisor and a consultant for more than 15 years. Stay tuned at the end of this episode to learn more about Advisory Resource Group and the offer that I make to every dentist who finds value in this series. Thanks everyone for joining another episode of 20 Minutes with Troy. Today I have John Hughes from McLane Middleton Law Firm with me. For those who don't know John, John's an incredibly well-respected attorney in the Manchester area. Really, I'd say all of New Hampshire and northern Massachusetts, John, these days, right? You guys seem to be taking over the world a little bit.
Correct. North of Boston.
North of Boston, right? But now you're in Boston too, aren't you?
That's true. Yeah, that's right.
So what we wanted to do today is really just do what I'd call an introduction to estate planning. Just kind of talk at 30,000 feet of why we do this planning, what's involved in it, what the process looks like, and maybe talk a little bit about kind of just put our toe in the water of some what we'd call advanced techniques, especially around the areas of asset protection and sort of liability, especially as it relates to dentists. So John, maybe I'll just give you a few seconds to kind of introduce yourself if you want to just give sort of a quick bio, and then we can kind of jump into it.
Sure. I'm an estate planning attorney here at McLane Middleton. We're a regional law firm, about 110 lawyers, 5 offices, Boston, Woburn, Manchester, Concord, and Portsmouth. My practice is solely in the area of estate planning and asset protection planning, although we have a number of other practitioners who practice in virtually every area of the law. So it's nice to be able to focus in one area, but it's also nice to be able to have other people around you that have their same focus in their own particular area, so you can cover all the bases.
Absolutely, and I can say, from experience, I've done a lot of work with John and McLane, and you guys have been a great firm to work with. So John,
Right.
Start with sort of why should people work through the estate planning process? Why do it?
So I like to use the phrase "get your affairs in order." The phrase estate planning conjures up images of money and a gate on the house and this sort of thing. Getting your affairs in order, I think, is a much better way to describe what I do. And I think getting your affairs in order captures people's attention a little bit better. It can be a little bit intimidating phrasing it that way, but it's a much better way to capture what it is that I do, right? And the concept is just that, is to have your affairs in order so that if there's a injury or an illness or a death, that all of the right pieces are in place to make sure that your family is protected and make sure your business is protected, and things can carry on either until you recover in case of disability, or at the time of death, that the family is not put in a even more difficult spot than it already is, so that things can move forward without undue stress on the family.
Super. And what's involved? What sort of, take me through the process a bit from someone comes in, wants to get started. What does that look like? What are they doing, and what are you going to need from them?
Yeah. So typically the way that we work is that we simply just meet and have a conversation. A lot of people are looking for checklists or things to fill out, forms to fill out, and that's really not how it happens. Everyone's situation is so unique that there really isn't a checklist for any individual that they can check the boxes and move forward. So it's a conversation. And the process of getting your affairs in order is to deal with not only what happens at the time of death, which most people would expect that conversation to be had, but also what happens in the event of disability, okay? People think that if they have a will, they're all set because they've got a will in place, and if they die, they've directed what happens at the time of death. A will falls short in today's world, and a couple places where it falls short. It first of all falls short in the sense that the matter of disability isn't addressed. You really need to designate who's going to be in charge of your affairs if you're disabled. That's too sick or too hurt to make medical decisions for yourself, or too sick or too hurt to make financial decisions for yourself. So where we start the process is talking about disability. Okay. Most immediate issue is healthcare. Who's going to make healthcare decisions for you? That is not a decision that can be made by default. A lot of individuals assume that if they're married, their spouse is in charge. That's not true. There is no law that defaults to your spouse in terms of making medical decisions. So what you want to do is put in place a medical advance directive, which consists of a healthcare power of attorney. Massachusetts, we call it a proxy, a living will, and a HIPAA release, HIPAA. That's a form. It's a very standard form, but it's a very important form that you've designated who's going to make medical decisions for you. Small decisions like which hospital you're going to be treated at, or big decisions like termination of life support and everything in between. So those are all the issues that really need to be addressed in terms of medical affairs. The other side of being disabled is who's going to manage your financial affairs. If your disability continues for any period of time, and not a few hours or a few days, but a few weeks, certainly your financial affairs need to be addressed. If, for example, you as the financial advisor are managing the investment accounts, there are certain accounts that are not joint. For example, an IRA, that's not a joint account. And then some people have accounts that aren't joint in the first place. And if you were sick or hurt, you need to make sure that someone else can make financial decisions for you. So if you, Troy, call up and give some advice, you need someone else on the other end of that line to speak to. And we put in place a durable general power of attorney to make sure that can occur. And that's a very important document to have in place. So that's where the conversation starts, is the disability. So financial power, medical power. Those documents and the issue of disability is actually more difficult to deal with from a legal perspective than death. A disability is a more serious situation from a legal perspective, a harder situation to manage than death. And it's dealt with by way of documenting those two things up front, financial power to medical power. Right? The other side of the estate plan is what happens at death. You should have a last will and testament, and virtually everybody in today's world should use a revocable trust. So it's revocable. That means it can be changed or amended at any time for any reason or for no reason. A revocable trust to a lot of people seems a bit intimidating because they read more into it than really exists. What a revocable trust does, it allows your assets to pass with little or no probate court involvement. Okay. So in today's world, virtually never would we simply use a last will and testament to transition assets. Although it's easier to prepare up front, it's very, very difficult to manage.
Sure.
And takes a lot of time and effort. What a revocable trust does is a substitute for the last will that directs how the assets can pass at the time of your death. It's particularly important when there are minors involved, children, because minors wouldn't even be able to receive assets. So for example, young couple has a last will and testament and they leave their assets to their children through a last will. It will happen. That's not the issue. But the issue is how difficult is it going to be? If that child is, for example, 2 years old, there'd be a 16-year probate court process open and ongoing, which is very difficult to manage and very expensive to manage over time. What a revocable trust does, it allows the individual to designate a trustee, that's their person, someone they know and trust, that's the word trustee, to make financial decisions and to carry out their instructions as laid out in the revocable trust without having to answer to the probate court.
Yeah, no, absolutely. And so, John, given the context of the audience today are mostly business owners, talk about sort of how that plays into the role of the documents that you just talked about. What additional planning considerations are now involved that we've got a business?
Well, getting your affairs in order is important if you have a 9-to-5 job. And even if you don't have a lot of pieces that need to be put in the right places. So if you have a 9-to-5 job and a home and it's pretty simple stuff, then getting your affairs in order is important. When you add in the layer of a closely held business, it gets far more important. That dramatically increases the potential for mistakes to be made after death. It dramatically increases the need to manage the death and disability to make sure you preserve the value of that business. Because, you know, if you own your own business, the decisions are daily, and those decisions need to be addressed quickly before the value of the business goes away. So addressing issues such as who's going to take over the business, how can that happen, making sure that your life is properly insured so that there are assets available to continue the business. That's all part of the planning and getting your affairs in order. And it's a part of the planning that just takes on a bit more importance when there's a closely held business as opposed to an individual who has a 9-to-5 job.
Yeah, and maybe go one step further when there's a partner involved. That even further complicates things as it relates to your planning, estate planning, and business planning.
Sure. And to some extent, your death or disability when you have a partner is a bigger problem for your partner than it is for you. They're the ones left holding the bag. So oftentimes the partner is the one that's more at risk than the individual themselves in the event of a death or disability.
Yeah, and I know we've both seen it of how devastating that can be to a business when these plans and documents are not in place. It can,
sure,
and for the family as well, because you've got a business owner who's then kind of essentially in business with the partner who passed away's family, which can also be pretty challenging as well from a planning standpoint.
Right. And it's important to address these issues up front while everybody's thinking clearly. You want to be addressing the matters of death and disability when you have the time and ability to think it through, as opposed to when you're under the gun of an impending illness or if there was a tragic accident or what have you. Just want to have all of these things said and documented so your affairs in order. Not so much that so that you can be in anticipation of an event such as a death or a disability, but so that you can get it out of your head, document it, have your affairs in order, and not have to think about it anymore.
Sure. So let's move on a bit to a topic that I'm asked about fairly regularly, which is asset protection. Certainly in the medical community and the dental community and so forth, we're worried about malpractice. We're worried about sort of what that would look like, what we can do to protect ourselves. Sure. There's special trusts available. There's techniques. What kind of take it from sort of the spectrum of what somebody does and what they want to be thinking about when it comes to asset protection and liability.
So asset protection. Oh, sure. So asset protection isn't all about any one particular technique. It's a combination of a number of techniques. The best asset protection has a number of layers of protection as opposed to one single transaction that facilitated that asset protection issue. Probably the most basic estate planning or asset protection technique would be to use estate planning. Typically, when there is an individual who has a risk, that would be oftentimes a professional, dentist, physician, attorney, financial planner, architect, engineer. There's a certain level of personal liability associated with that. And that comes with the territory as being an individual professional. And oftentimes what we'll do is while we're getting individuals' affairs in order, we'll use a revocable trust to make sure their affairs in order. But when we're entering into the realm of asset protection, oftentimes with a spouse, we'll enter into a transaction where we have a trust for one spouse and a trust for the other spouse. It's really not that much more complicated because the trusts are mirror images of each other and they look almost identical. They refer to each other. But the concept is you can actually hold your assets in your spouse's name. The non-risk spouse can hold many of the personal assets. So the home, the nest egg account, that sort of thing is held in the trust of the individual who is far less at risk, the non-professional, okay? And that isolates the risks from the professional's liabilities and can be a really effective technique when that's available, okay? Of course, it's not available when you're not married because we don't have the spousal exemption to deal with. In that case, sometimes we enter into asset protection trusts. Those are irrevocable trusts. So the assets are given away irrevocably, and they are held in trust in a manner in which, if the individual were subject to liability, that those assets cannot be returned without the trustee's consent. So in essence, you place your assets in the hands of a third party. That's another level of asset protection. Okay. There are other assets that are out there that can be protected fairly easily as well. And an IRA is very well protected for asset protection purposes. That varies a bit from state to state. And then homestead elections, making sure you've got a homestead election in place on your primary residence is always helpful. And then the technique of isolating assets into different entities. Right? So a professional that operates their business would want to operate under a professional LLC, or what we used to use in corporations. They would be PLLCs now, professional limited liability companies. That would isolate the liabilities inside that particular entity. And if the individual also owned their own office building, perhaps, that would be a different LLC. And the concept is really keeping liabilities in silos. So if there was an issue with the building, it doesn't affect the practice. If there's an issue with the practice, that it doesn't affect the building. And you build these various silos so that they can be contained from each other and they don't get infected by each other's liabilities. And at what level does an individual engage in asset protection? That really depends on the situation, and we just lay it out. There's a lot of pretty simple techniques that can give a whole lot of protection and give individuals a whole lot of peace of mind without a lot of moving parts. You also need to consider you need to maintain this going forward. You don't want to set up a structure where it's too difficult to maintain on a day-to-day basis. So keeping it as straightforward as possible is important as well.
Yeah, that's an important point. How often do these things need to be reviewed? It's not uncommon that I'll meet with someone and ask, do you have your estate planning in order? Do you have the documents? And they say, oh, absolutely. And then they, kind of grab something off the shelf and blow the dust off of it and give it to me. Are those documents still good? How current, and when you're kind of talking about this, how regular do we need to be reviewing it?
Mm-hmm. About once every 5 years, I think, is a reasonable interval. Certainly, if there was a major medical event or an accident, that would be reason to review it again. But about once every 5 years is a good interval. That doesn't mean they redo everything once every 5 years. That's probably not the case. But just want to take a look at, for example, an individual who named someone as their healthcare power, and it's a good example would be somebody had named their father as their healthcare power or financial power, and their father now is getting on in years and is no longer capable. You'd want to look to another individual, maybe someone of an even generation, a sibling perhaps, or later on in life as children mature and are capable, you could have the children serve in that role.
So, kind of, I think, coming to sort of the end of our time today, talk a little bit about what would somebody expect, and I know it's again a spectrum based on the level of complexity of business and entities and so forth, but what should they expect as it relates to cost when they're coming in to do an estate plan?
Mm-hmm. My practice, I try to always prepare estate plans on a flat fee, so individuals know precisely how much it costs upfront without having to worry about hourly costs. It's always interesting to me that an individual will ask what an hourly rate is, which is an interesting question, but it's not a complete question because you don't know how long it's going to take. So virtually all of the estate planning that I do, I prepare on a flat fee basis. And I do it that way because I like individuals to ask questions, know exactly what they're doing when they are going through this process. I always say to people, if as we get through this process and we're meeting to execute documents, if there's anything you don't understand, don't sign it. Unlike a lot of things in today's world where you click to accept or sign here, and there's so much disclosure, it's almost to the point where it's over-disclosed that you couldn't isolate what the issues are from the non-issues. In this instance, getting your affairs in order is all about understanding what's in place, how it protects you, what the issues are, and knowing that your affairs in order, not just being told your affairs in order, but in fact knowing exactly how things work and having that comfort level. So putting things on a fixed fee, people know exactly before they start, that's how much it's going to cost. I know what I'm getting. I'm going to ask my questions. I'm going to make sure that we get through this process. It also allows you and I to work together without having to worry about hourly fees to the client as we go through some of the estate planning process, which very much involves the financial team as well. An estate plan can be as low as $950 for a person, and then it can go up from there. What I do is first meet with an individual, find out what it is they want to do, and then lay out exactly how much it costs and how much each piece is, so they can determine the value of it. But a good budget would be, for a married couple, would be about $950 per person, and that's a pretty good estate plan if you've got some of the basics in place. Asset protection would be a bit more, and it would just depend on how much you want to add to that as things go forward, and you can build it over time. It doesn't need to be built all in a day.
Yeah, and that's a good point. So when, if you look at my practice, I'm working with dentists at all stages of their careers. And, one of the questions is, when do I need to go see an attorney? So when would you, someone's just out of dental school, they're an associate out of practice, they don't have any children, do they need to come see you? Is it really, is it the house? Is it the child? What's sort of the impetus of them needing to come and chat with you?
I think upon reaching adulthood, I think if you're out of dental school, you definitely want to have your affairs in order. Young individuals can deceive themselves in that they could say that I don't need to have my affairs in order. I don't have anybody that depends on me, and that's one way to look at it. But the other way to look at it is you have a life. You have yourself to protect. It's not all about money. Medical advance directives have nothing to do with money. It's all about making sure that someone else can make medical decisions. And it's really about having your affairs in order so that there isn't undue hardship on yourself if you're sick or hurt to make matters worse, or on your family. So really, any individual young professional should have their affairs in order. Once children enter the picture, I think it's definitely an issue. People often associate getting their affairs in order with being older, which is always a relative term. And it's really not true. What's interesting, a young family with young children, I would argue it's more important to have your affairs in order than a mature family. A mature family that if you die at 102 and your children in their early 80s, they'll figure it out. A young family, if there's a death or disability, and there's minor children involved, those minor children can't protect themselves. Okay? So although the risk of death is low at a young age, that's true, the impact of the death is so high that on balance, I would argue a young couple is more at risk in terms of having their affairs in order than an older couple.
Sure. Yeah, I think that's an important note. And I think, oftentimes people probably wait a little bit longer than they should. And sometimes admittedly, and they know that, but I think even when that's not the case, I think people probably wait a little longer, and it's good to come see you probably sooner rather than later isn't a bad thing. And something that I preach often in my practice is the creation of a team and the collaboration of that team. I think you're a very important member of that team. And again, people think about it death, but it's really not just about death. It's really about life as well, and managing a number of different issues, again, especially as it relates to businesses, and especially as those businesses have partners and so forth in them. Again, I think the number of times that we need your advice and your input to that team is more than people might often think. So, I think that's incredibly important. So, well, John, this was a lot of fun today. Not always one of the most glorious subjects, but an incredibly important one. And again, for those watching, I can speak from experience. I've worked with John, gosh, I'm going on 20 years in business, and I think I've known John for, maybe all but 3 months of them. So, and certainly speak to the quality of his work, and certainly the firm as well. And I'm just going to do a quick commercial. And one of the reasons I lean on McLane the way that I do is because of the depth of the firm. When you've got 110 lawyers in a New Hampshire firm, and I think you are still the largest firm in New Hampshire, there's always a hallway that you can walk down. And so if there's an issue or there's something that you don't know, you've got somebody right next to you. And I think for a lot of the business owners, a lot of the practices that I'm working with, that's important, because we might have human resource issues, we might have corporate issues, there's a number of things. And so to me, that's one of the reasons why working with a larger firm gives us that latitude to be able to get that information. So again, shameless self-promotion that you didn't have to do, John. So
thank you.
All right, buddy. Thanks for your time today. Anything else that you want to add or anything else important to talk about on this subject?
Hopefully individuals will start thinking about having their affairs in order, and I think it's actually a pretty pleasant process, as intimidating as the topic can be. I find that once people sit down, get their affairs in order, what they get is peace of mind, and that's really what I try to strive for, is making sure that individuals are very comfortable with what they're doing, knowing that their affairs in order, not so they can dwell on it, but so they don't have to think about it anymore, and have the peace of mind knowing that things are in order.
Sure. Well, thanks again for your time today, John. Your information will be on the screen here in case anybody wants to reach out to you. And thanks again. Appreciate it, buddy. Thank you for joining us for this episode of 20 Minutes with Troy. My firm, Advisory Resource Group, has been assisting the needs of dentists and medical professionals at all stages of their careers for more than 15 years. I'm both a financial advisor and a practice consultant, acting as a problem solver and facilitator to provide one-stop shopping for those seeking strategies, advice, and connections for the challenges that accompany every stage of their personal and practice lives. As a co-pilot and a friend, I assist my clients through the navigation of practice purchase, succession, expansion, attraction and retention of team members, partnership and associate planning, refinancing, and a myriad of other advisory, investment, insurance, and retirement services. I make the offer to meet with every dentist by phone or in person to introduce them to my firm. I don't assume that anyone has a need or interest in our services. My goal is to learn about any pain points they may be experiencing and to establish myself as a resource, whether it be for now or in the future. Please take advantage of this no cost or obligation offer by contacting my office or visiting advisoryresourcegroup.com.